Morning, it's Monday.
Good morning, right, Sean?
You're on mute. Yeah. Let me know if they. Okay. Yeah, it's an important project. Wayne. Aaron, you go to Randy. Aaron, so you'll continue. You participate both ways? Represent that you right there? No, that's. I have my contacts in. So that's not you? On the left, no? No.
No,
Jennifer.
that's from CSD. Blonde hair.
George. All of them, right? I got started. She got me over the top. It's about these are world there. So. Hello, everyone. I hereby call this meeting of the task force to order. It's 9:05. Got all our tech done. And I've got one for you because I can't see. They got this so that I could see and call on people that are closer. Aloha. For those who are here physically and those of you who are here online, thank you for your presence at this special meeting that we have called for today. Just for some opening remarks. It's been a good journey that we've all had this year. And, you know, this past 4th of July, I was fortunate enough. Well, I had business to do in Washington, D.C. I was able to be there on July 4th. And me and my wife was able to lay on the lawn, the towering Washington Monument above us. And we were so happy to be there, and then it rained. Then we kind of ran because we were invited to the Department of Interior's rooftop to watch the fireworks. And when we got up there, we saw 1 minute of the fireworks, and then the smoke was, the air was so thin, the smoke just stayed in the sky. So we didn't see any of the fireworks. We just saw the tail ends of the light as it fell from the ground. And so I said, was this an interesting July 4th week? She goes, yeah, at least we got to learn how to ride the subway. You know, and so as I end out July, I'm looking for some kind of light in my bad month that I've had in the nation's capital. But at least I can say I was there for the July celebration, and it was an experience nonetheless. So as we begin our meeting, I wanted to give a roll call, see who's here. Please respond to present when your name is called. Judge Souza has already informed us that he's not going to be able to make it, so I'll move forward. Lisa, Morris.
Here.
Brenda Bauer-Smith.
Here.
Tommy Johnson. Present. Kuike. Present. For those of you who may not know Kuike, he is the delegate chosen by Carmen Bulu, the chair of the Office of Hawaiian Affairs. Fred Yoon. Yep. Ben Lowenthal.
Hello, this is Andrew Kennedy. Ben Lowenthal's on his way. He just texted.
Thank you. Mark Hashem. Glenn Wakai.
Present.
Thank you, Senator. Steve Ong. Here. Keola Siu. Present. Andrew Martin. Present. Keldon Watchin. Pamela Ferguson Bray.
Here.
Miles Briner.
Present.
Brandon Siegel.
Good morning, I'm present from Maui.
Thank you, Brandon. Andrew Kennedy.
Good morning, present from Kona.
Thank you. Craig DeCosta. Sonoy Kaihui.
Present.
Then Martha Ross.
Present.
Thank you. We have quorum. I believe 4 are not here at this time. If they show up, George, let me know. Okay. We move on as we to item number 3 on the agenda. And I'll review the task force previous work and the charge. Now I'll provide a summary of the previous work is done by the task force. The charge of the task force is as follows. Oh, I'm sorry. In the first meeting, we reviewed the many different ways that the states arrange their sentencing and prison release systems. In our second meeting, members of the task force walked through the state constitutional and statutory provisions that bear on sentencing and minimum settings, and the role of judges, prosecutors, defense counsel, victims, and the HPA. In our third meeting, the HPA provided 3 scenarios for holding minimum hearings under the guidelines based on actual cases. And in the fourth meeting, we highlighted the most common feature of other indeterminate systems, the use of fixed minimums, and proposed the task force consider that option. Yeah. Task force, our charge. 4 bullets. Examine and make recommendations regarding existing procedures of the Hawaii Paroling Authority, setting the minimum terms of imprisonment to increase the efficiency of the procedure. Study whether parole systems models utilized by other states might be suited for Hawaii. Examine and compare the minimum sentences issued by the Hawaii Paroling Authority and the courts to determine whether there are significant differences. And fourth, recommend whether the administration of justice may be better served by removing the responsibility of setting minimum sentences from the Hawaii Paroling Authority, thereby enabling it to focus on determining and assisting prisoners' fitness for parole and supervision of parolees. To ensure that our meeting is productive, fair, and efficient today in the discussions that we are about to have, I will review some guidelines for the order of this meeting. I'd like to begin with the Aloha statute. Hawaii Revised Statute 5-7.5/2023. Basically, it's the law spirit. It's the coordination of the mind and the heart within each person. It brings each person to the self. Each person must think and emote good feelings to others in the contemplation and presence of the life force. Aloha, the following loa may be used. And as we look at the acronym of aloha and the different letters in it, A is akahi. A is akahai, the kindness to be expressed with tenderness. L is lokahi, unity to be expressed with harmony. O is olu, it's agreeable to be expressed with pleasantness. Ha'a, humility to be expressed with modesty. And A, ahunui, patience to be expressed with perseverance. These traits of character express the charm, warmth, and sincerity of Hawaii's people. Aloha means mutual regard and affection, extending warmth and caring with no obligation in return. It is the essence of relationships in which each person is important to every other person for collective existence. Aloha means to hear what is not said, to see what cannot be seen, and to know the unknown. Takes us to item number 5 on our agenda. And probably the length of our meeting. Okay, thank you everybody for being patient. All right. We want to have a discussion today in charge of the task force. And we have put together some questions that we have set in the agenda to facilitate that discussion. We want to have it hear from everyone who has been present here. So I will be calling upon you in terms of giving your thoughts on the question as we discuss it. And we'll go over 3 questions. Yeah, it's good that everybody be able to give their manao or what they feel as we begin to move toward a possible conclusion or discussion, further discussion on the recommendations. So, first question is sincerely, do you favor and I believe it's written in your agenda, folks. I'm just going to read it for purposes of clarity. The status quo where the Hawaii Paroling Authority continues setting minimum terms of imprisonment, or B, an alternative minimum setting, removing the responsibility of setting minimum sentence from the Hawaii Paroling Authority. I really want to keep to those 2 points, status quo, or an alternative minimal setting, removing the responsibility of setting minimum sentence.
So sorry. I have a question, just a brief question about, as we're framing things. As we read our charge and it said an existing procedure rather than status quo. For me, status quo is kind of a negative framing. Language is so important to all of us. And I just wonder if we could maybe think through when we go forward instead of using status quo, because it sounds negative, but go to use what's in the resolution, which is existing procedure.
Yes, that's a good one. Thank you. You say existing procedure?
Yeah, that's what you read as
Okay.
it's our charge, looking at the existing procedure.
So, as I call upon you, take into advice your response in regards to the existing procedure of the Hawaii Paroling Authority, continue setting the minimum terms of imprisonment or an alternative minimum setting, removing the responsibility of setting minimum sentence for the Hawaii Paroling Authority. We have set aside 46 minutes for this conversation. And I'd be honored, Prosecutor if you start the conversation, and I'll call upon you.
Okay. Well, I would favor keeping it with the paroling authority, but with some changes, a little amendments, maybe hiring Dan Foley and/or somebody else to go over the guidelines again with modern sensibilities in mind. Because I think while our judges are pretty lenient, the paroling authority's minimums are fairly long. And so I think it would be worth looking at that. And I think the net result would be, it would probably decrease the minimums across the board. And I've learned a lot in this procedure. It had been decades since I've been to a minimum hearing, that in many ways, it's a superior hearing to sentencing. And I say that as a judge with 15 years, because what we learned from the victims is they feel more comfortable there. They don't get the stink eye from the defendant or his family. The press typically is not there to see all this. It's more comfortable. And as a judge, you'd ask the defense attorney if your client would like to make a statement, and almost invariably the answer is no, we're going to be appealing the case. So on my advice, not saying anything, but she's not saying anything. Whereas the Paroling Authority actually has a dialogue back and forth with the person who's getting the sentence. So a lot of arguments are. It also provides some consistency statewide. And if it's not with them, the judges could really be varying. And we don't want a situation where more than it already exists at arraignment of plea, the defendant knows I got a quote good judge who's going to give me a low minimum or give me not send me to prison to begin with, or this judge might do that. And I think there's lastly, I don't think the judges want this responsibility. Right now, they don't have it. And it's really rare for anybody to get sent to prison unless it's mandatory. So this would require, if there's some kind of a minimum that's out of the Paroling Authority, I would think so. And lastly, I don't know if you want me to mention, do you want me to say anything about the Penal Code Review Committee?
Not at this time.
Okay.
It'll come up.
All right, thank you.
I'm so sorry. I just have a quick question. So are we voting as we speak? And
No.
okay,
Discussion.
you're just giving our kind of presentation of what our thinking is
Yes.
now. I see.
Ben, are you online?
I'm right here.
Oh, I'm sorry.
The answer is no.
Okay, that's a good answer. You wanna.
Sure. In thinking about the question before us today, I think it's important to take a very good look at the numbers, notwithstanding the rationale of the individual cases. I take consideration with Mr. Long said, to agree, consistency is important, not only for victims, not only for the public, but from the defense's standpoint, consistency from day one will allow us to advise clients with a degree of reliability. I do believe the alternative proposal gives us that consistency. On day one, you can look at the charge and know what the minimum is going to be, absent motion, absent some sort of act on behalf of either party. And that allows prosecutors on the other end to have that meeting with the victim and tell them on day one, even at pre-charging, we can look at it pre-charging and know what the minimum is going to be. It is not left to the full board with their discretion years, months after the sentence, or even years after the charge to know what a minimum term would be. And it would provide closure for victims. It would also provide that certainty for defendants. So I believe the alternative is not only worth looking at, but it's worth pursuing.
Mark, I don't mean to interrupt, but then are you looking at the third option that we really haven't discussed much about the legislator setting the minimum? Because what was originally proposed to this is each judge would set the minimum. So you
Right now, we're
know
just
that.
dealing with that one question. He's just making his
Right.
remarks.
I was going from the idea of the legislature setting the minimum from the last meeting. Yeah.
If we can just really just focus on the question at hand, but thank you.
Sure.
Ben, appreciate it. Keola?
Yes, I'm in favor of option E. Having, determinate sentencing, obviously that would be set by the legislature. It's a better option, more predictability, less time in pre-trial. I think that time in pre-trial, there was a lot of discussion in the in the public hearing about so-called dead time, it's not very productive, for any. So I think if, they know, basically what their sentence is going to be, and allowing the judge to, the judges can either go above or below ranges. If that's something that makes a difference with traditional democratic point system. So I just think it's a fair system, if we went to determine sense.
Thank you, Kilo. Miles?
You're muted.
Can't hear you, Miles.
Who can't hear you?
Excuse me, can you hear me now?
Yes,
Okay, so the question before us is what option I favor?
yes.
Option B. I want to restore this authority to the judiciary and, with all due respect to the parole board, remove the arbitrariness of a star chamber and opportunities for the prosecuting attorney in each of the districts coming and getting a second bite of the apple where the defense can't present any witnesses. So I made that clear from the outset, and I stand by that position on behalf of Hactl. I hope most of my colleagues support that are in Hactl. I think you need to make sure that we're not behind the times. We're the only state that allows this type of authority with the parole board. Thank you.
Thank you, Miles. Prosecutor Martin?
Thanks, Mark. So I favor exploring option B. For me, and I'm gonna, it's hard for me to sit here and disagree with the take of former Judge Alm, who was on the bench for 15 years. I don't mean to say for some reason I know differently, but for me, the biggest reason to go with option B is because I think the judges are better positioned to be able to make that determination. I think they have more information. I understand that it may be the practice or the occasion in the First Circuit, whether now in the past, where there isn't much of a dialogue with the defendants, but I can tell you that's not what happens in the Second Circuit. I love Judge Cahill. Sometimes I wish he had less of a dialogue with the defendants, to be honest with you. I think the information gained throughout the entire process of litigation of a criminal case puts the judge in her best position. I'll say that with one caveat, that the idea of being able to set statutory presumptive minimums, with the judge being able to make findings of aggravating and mitigating circumstances on either side, is the one that interests me most. And I think would have the biggest impact. I do think it gives more of a certainty toward everyone within the system. I have had victims who have had wonderful experiences in court, bad experiences in court, victims who had wonderful experiences in front of the paroling authority, victims who refuse to go inside. I think those arguments can be made on both sides, and but I think that option B is the one that should be explored and could provide a meaningful step forward for us.
Thank you, Prosecutor White. Mr. Kennedy, Big Island?
Well, thank you. I would agree with option B, restoring the authority to the judiciary. I strongly agree with that. I think, as was just mentioned, the judge knows the case better than anyone else. I think they gave a more thorough review. They understand what went into whether a plea agreement was taken or a conviction at trial. I disagree. It's a burden to the judges. I think at least the judges that I'm familiar with would welcome the ability to control their own cases. And I think it allows for more certainty for all the parties, whether it's the victims or the defendants, in the negotiating process. as well as the sentencing process, what they might be receiving, as opposed to having it set half a year out with just a wild card, not knowing what's going to happen. And in terms of consistency, while I know there was a concern about statewide consistency, but consistency within that court, I think, would be maintained. And I think right now the system's so inconsistent that I don't believe that call for statewide consistency is really realistic, because it's so inconsistent now. So thank you.
Thank you, Andrew. Yeah, let's just stay on the Big Island right now. Keldon, are you there?
Good morning. Can you hear me?
Yes.
Okay, sorry, I was having technical difficulties this morning, so I did miss a portion of my colleagues and their recommendations and input. You know, I know we have here 3 options laid out. I've been going back and forth, and I've talked to my
Keldon, can I repeat? You may have missed it. We're just looking at right now, question 1. Do you favor the existing procedure where the Hawaii Paroling Authority continues setting the minimum terms of imprisonment? Or B, an alternative minimum setting, removing the responsibility of setting minimum sentence from the Hawaii Paroling Authority? That's the
Got it.
question.
Option B, please. I guess I can briefly elaborate. I've spoken to my staff. We've gotten input from our victim assistance unit, and some of the concerns trying to balancing both sides is that we have had some there's some victim safety concerns on what's been handled with this dead time in between, where we have people stuck in custody and not addressing certain types of concerns for the offenders. What a lot of times is happening is I'm seeing that sentencing courts, trial judges are electing to sentence offenders to probation terms instead of imposing prison terms because of this dead time, so they can possibly try to facilitate a form of a term of conditional probation that they think that individual will not be afforded unless they're sentenced to a prison term, and where they wouldn't be afforded that opportunity if they're sentenced to a prison term. So they're using that dead time to instead, and being quite lenient and sentencing people to multiple revocations of probation and not imposing a prison term. So, you know, in balancing some of those types of concerns, we think that it would be appropriate to go with option B at this time. But I do have a little, when we get, I guess, further down in the agenda today, I'll just be upfront and honest. It's kind of hard to go with to determine between option B and C in the later agenda questions.
Thank you, Keldon.
Thank you.
Brandon, are you online?
Yes, I'm here. Good morning, everybody. So I strongly favor option B. I'm speaking as not just a defense attorney now for the past couple of years, but a former prosecutor for almost a decade, about 9 years. And I understand we're not on this section yet, but when we talk about whether or not that serves the administration of justice, you know, I've actually worked closely with Mr. Martin on defining what it means to pursue justice. We've expended lots of resources and time with working with staff about defining justice, how to administer it fairly. The biggest missing piece I found as a prosecutor, and I've negotiated hundreds, if not thousands, of plea agreements. I've obviously done sentencings, is the HPA. I think that's a hindrance to the prosecutor's duty to administer justice. It's a hindrance to the victims, especially when you're in situations where it's either probation or 5, 10, or 20. I think putting the discretion back in the hands of the judges and the parties who know the victims, who know the witnesses, who know the defendants, oftentimes have gone to trial and heard the evidence. I think that solves a lot of the problems with what many feel is sort of the subjectiveness or the arbitrariness of the HPA minimum setting process. And so I'm asking for option B not just as a defense attorney, but as a prosecutor as well. Thank you.
Thank you, Brendan. Pamela?
I support, I think everybody's gotten a copy of the memo from the Attorney General, which supports position one, but also has some additions to resource related and other additions. So I support that. In looking at the uniformity of sentencing, the parole board currently uses guidelines that are approved by the Supreme Court that are essentially uniform compared to what individual judges would do. And for those of us in the victim community, I think it's important to note that the legislature decided to include a representative from the sex assault community and domestic violence community, is that in all the years of lobbying to make sure there's a mandatory penalty for spouse abuse, because judges weren't sentencing offenders to anything in abuse cases in the past, to look at a history of the disparate treatment, particularly of crimes related to domestic abuse and sex assault. I mean, certainly that's one of our red flags on this, talking about, when Keldon was talking about the fact that judges regularly on the Big Island just waive pre-sentence, don't even have to know anything to do sentencing. That's the system that we're looking at, is, his comment now that judges are not sentencing, they're just, rolling the dice and I guess recycling over and over these cases instead of doing sentencing. So if that's the judiciary system that we're looking at, as opposed to a system where each individual case is looked at by a parole board using guidelines that are approved by the Supreme Court in a uniform way across the system, as opposed to just looking at what we described as the disparity between each of the counties in sentencing, then certainly we favor the uniformity of the parole system, and that for victims as well. Victim notification. There's no mechanism in the judiciary to notify victims as required by statute. So that the key rights that victims have under the statute, under these other proposals, essentially evaporated. The judiciary declined to join the Savin system to create a system for victim notification so that they can put on sentencing. They declined that. In the Savin system, the automated notification system was created. So there's nothing for victims there. The right to be heard in the sentencing of B permutation was a right to be heard after a third of the sentencing was done. And it was not a right to be heard in person, as the current rights are. It was a right only to say something on paper. So there was no right for victims, no statutory right, which they have, built into that system. So it's already, even on its face, a system that does not favor, I think, justice for victims and also justice for offenders, which is about uniformity, about people making decisions about where they are, what their needs are, so that they won't reoffend. So we think that victims and community safety would be really negatively impacted if we do not continue with the current system.
Thank you, Pamela. Brenda?
Okay, so, the Department of Health, I'm here, place for the Deputy Director for the Department of Health, didn't take a strong stand either way on this. Some concerns, though, open to leaning towards option B, but some concerns were just a question of what, if any, is the issue that does HPA have an issue with the current system? And what could help HPA be more efficient if they were to retain the responsibility? There was concern that if it were to the judiciary or that proposed percentage, that percentage amount, that it seemed too static. It was too, it didn't allow for, they thought that there should be consideration for the heinousness or the mitigating circumstances or aggravating circumstances for an offense. And I guess just one of the questions would be that if it were to be, so if a specific percentage was set, say, the 33 or whatever percentage, which notably was significantly less than current minimum that people are spending in jail. could a judge inflate or deflate his or her sentence just based on the knowledge that a certain percentage would be spent?
Martha?
And, well, after listening to the presentations and the data procedures that were discussed, and our colleagues, and then also talking with the victim services and victim community, it really seems to me that the current, more individualized, thorough assessment by the HPA serves all better in terms of justice. And I would say that they could review their guidelines just to see if any updates are needed. And also, it seems to me after listening to everyone, there is a need for more funding for incarceration, for offenders that are incarcerated programs. And also, after hearing victims tend not to necessarily speak up or provide their input through fear or whatnot in all settings, it seems like maybe more post-conviction staffing for victim services is needed. So that I'm saying that here because as I'm looking at what's going on here, I'm not sure we're going to be able to talk about the existing services after this discussion, but it really seems that it's the more individualized and thorough assessment that HPA does. And I didn't really see anything wrong with that approach. I didn't hear any data presented in that to that extent. So anyway, that's my perspective.
Thank you, Martha. Lisa?
Well, I do favor the existing procedures. I think there are ways to make it more efficient and I guess provide more options or more certainty for the vendors. But just on the initial question, I think the existing procedures.
Thank you. Tommy?
I think the existing procedures are fine. Maybe they need some more manpower, and I do agree though that a third entity may want to take a look at the administrative rules, probably update them. They're from the 1980s, if I'm not mistaken. I agree with Pam said about the minimum sentence process. I also believe that when HPA in its current form and authority deviate from the minimum sentencing guidelines that are approved, they have to provide a written justification for the minimum order, justifying the deviation from the minimum term guidelines. I think that is sufficient. I also would like to provide clarity. Mr. Bryan mentioned earlier, he likened the minimum term process to Star Chamber. That refers to a movie from the 1980s of Michael Douglas where judges got together and decided if someone's going to be killed or not because they got off on a crime. The minimum sentencing process is open to the public. So it's nothing like that. And I want people to understand, I was an administrator with HCA 16 and a half years. And this is by far the best deliberative process you're going to find in the country because there's open discussion back and forth between the attorney, between the defendant and the parole board. And so I think the current system works. I do agree it needs to be tweaked some. I agree with the recommendations that the HPA chair put in a letter, and I'll just leave it at that. Thank you, Tom. You're welcome. Mike, I'll go. We would be in favor of option B. Nothing more to discuss. Thank you. Senator Wakai.
All I have to say is, you don't want option C because you don't want us lawmakers determining how we're going to get through this situation. I mean, we're all generalists at the legislature. 2 years ago, I wasn't even in this arena. I was pushing economic development. So I don't think we should, I know we're not there yet, Mark, but don't contemplate option C where you guys punt this to the legislature to figure out what the minimums are going to be for these individuals who are accused of offenses. So I'm receptive to however the committee goes forward, but I would be really, really hesitant for anybody to have option C, which is coming up later, as the means to resolve differences here.
Thank you, Senator. Sonoy, how are you?
Hi, I'm here. Yeah, I would agree with Senator. Option C is not an option. So yeah, I think as far as what I've talked to some victims about, I believe for this purpose, option A is something that I definitely want to support. However, there are, I believe that there needs to be tweakage. There needs to be things that need to be sort of fixed in that arena. However, I'm always on the side of the victim and them having a voice. And so I think option A gives them the best opportunity for that. And I agree though, that there needs to be a little bit more efficiency on HPA side. And yeah, I think Martha and Pam and others have already shared, my similar opinions, but yes, yeah, option A.
Thank you, Sonoy. Morning, Fred.
Oh, next best to the last. Anyway, before I say anything, can everybody review what I sent out regarding HPA's position and recommendation? Yes, because as long as you've read it, then fine. But so while we agree that there are changes, and because with CSG's presentation was a great exercise for us to relook and reassess. And basically our response is that we look at option A with the recommended changes that HPA has proposed to make it more efficient, more humane, not necessarily consistent to defense or prosecutors' positions, but, and no disrespect to the judges, but in this type of matter, we don't necessarily feel that judges know everything as far as setting the minimums versus a 3-panel type board that interacts and dialogues with inmates, with recommended programs and staff, who would have a better idea and concept of setting the minimums and programming them with assistance from Department of Corrections and Rehabilitation. We get prosecutors' inputs, victims' inputs, So I'm looking at courts adjudicating and sentence. Let DCR and HPA do the necessary treatment and rehabilitation and assessment and risk to the public. That's our mission. I mean, there's no doubt about it. Fortunately, I've been exposed to other states and other countries and how they do things. Hawaii is unique. Hawaii is an isolated geographic group of islands. And I think we know our people best, and that's why we're unique. We address the disparate populations just as other states don't. So in our concept of the changes that we need to do, works hand in hand with corrections as well as with rehabilitation and victim witness. We work with any other body, and we hear arguments. And because the setting of minimums are so diverse and we come across many unique, very unique situations, and we have the ability to reduce minimums except those that are imposed by the court. And that can prevent and slow down the rehabilitation and parole process. So I would go with option A, but to seriously consider what we've documented but we seriously consider documented as the changes that should be made to an entire system to make it fair, humane, and consider all parties. All parties. Thank you.
Thank you for joining us, Craig. We see that you're now online. Do you understand the process right now? You want me to ask the question again for you?
Sure.
So right now we're discussing and we've been asking everyone simply, do you favor A, the existing procedure where the Hawaii Paroling Authority continues setting the minimum terms of imprisonment, or B, an alternative minimum sentence, removing the responsibility of setting minimum sentences from the Hawaii Paroling Authority?
Yeah, so we're just vocalizing now, or are we actually voting?
Yes. Just having a discussion right now on how, where you feel on that question.
Yes, I'm in favor of option B. I did read the HBA's position statement. I haven't attended that many of these meetings, but I have reviewed the discussion points and handouts. And so I've been keeping on top of that. And I think option B is the fairest way. I don't believe that the judiciary has a lack of empathy for victims, or that victims would not be heard by the judiciary. I think having the HBA focus on what the person's conduct is in prison and plan for after prison would be better suited, that their focus would be on that and when to let them out and what programs that they've completed, what plan they have so they can be safely transitioned back into society. I think that should be the focus, and not, I mean, to use not a better word than punishment, by setting the minimum term. I think the courts, and this is something I believed from when I was a prosecuting attorney. My personal position was that I've seen a lot of cases where the victims hear, oh, a 20-year sentence. And then, 6 months later, a minimum terms hearing is held by a completely different board. It's not the judiciary. And now they hear, oh, but it's an 8-year minimum. And I don't think that that's fair to them. I think it's actually better mentally and for closure that they hear 8 to 20 from the beginning. And then they know that it's at least 8, it might be 20. They can still show up at parole hearings to say, I don't think this person's ready, or the community's not ready, or the family's not ready to heal from this, and oppose parole, even if the minimum terms have expired. So I don't think it takes victims' rights away. I think it actually helps them process this from the beginning. With respect to any, accountability, I think the judges are, at least in the public's eye, more accountable for their actions and decisions than the paroling authority in terms of setting minimums. I don't think many people pay attention to the minimums. And I've personally had an issue with certain board members making certain inappropriate comments, statements, and taking certain inappropriate positions at certain hearings. And so I would trust that the judiciary would be held to account more easily than the HPA and the administrative body.
Thank you, Craig. Appreciate that. I think everybody is in the meeting at this time except for Representative Hashem, so that folks know. So Representative Hashem is not here, as well as Judge Super. As I heard that discussion, and I appreciate the honesty, transparency, and the passion that each of you have from the specific point of the system. I wanted to move forward, and as I look at question 2, and I was listening to you folks speak, I really want you to expand on what you have, the position that you spoke earlier on. You know, so we look at question two, and literally just two, sorry. If we were to retain the status quo, would you favor no changes at all or consideration of other recommendations? Some of you said that, but we want to just go through that again. And then secondly, if we were to change the status quo to the alternative, would you favor judicial setting versus statutory settings? Yeah. Any questions?
I think we changed the status quo language on the question.
My side, my bad. Yeah. Get around.
Okay, can you repeat what the question is?
Just based on your previous answer, if we are to retain the status quo, I'm sorry, if we are to retain the existing procedure, would you favor no changes at all or consideration of other recommendation? And then give some examples.
Again, I think Fred, made some good recommendations. I think we should rewrite the guidelines. And I think it would throttle it all back. I think it might, it's a pretty, cost efficient, operation now, but maybe we could add a couple more Paroling Authority members if they could not, have different groups here. So, if that would ease the workload somewhat. Because I think them allowed to have this dialogue is incredibly helpful because for judges, 90% of the cases are favored. So if a guy goes to trial, I get to know really well, but if it's a plea agreement, I read the PSI, that's pretty much it. The motion to suppress, maybe. But I do think, we should be wide open to making the Paroling Authority more efficient, maybe give them some more resources. And I think Fred came up with some good ideas, including requiring PSIs, which might be a challenge for some of the prosecutors.
Thank you, Phil. Ben?
Okay, question two, assuming retain status quo favor. I think,
No, the other
Sorry.
one, the other one is yours.
right.
Yeah.
Oh, so what I said earlier?
Yeah.
I see. I do want to address that for a second.
Okay.
Assuming that ultimately we do retain the way things are. I think a significant thing that needs to change, not only the substantive guidelines or whatnot, it's a procedural fix. And it is something that I think we tried to get going in the legislature last session, which was we need to have better judicial review of what the parole board does. There is more judicial review. So let me just back up. If there is a challenge to the setting of a minimum term, if the guidelines were not followed, if say a statutory procedure was not followed, or even if there was abuse of discretion, the only way to get that in front of the judge is not with the case, but is by having an expecting inmate to file a separate petition and proceed in form of operatives. This can be, if there is going to be any tweaking of the procedures, my strong suggestion is that we have a mechanism that would allow attorneys to get back in front of court to see what the parole board did sooner and faster. Now, going back to what I said earlier, I would like to say that after listening to some of the answers, especially from some members of the legislature, if they're telling us don't leave it up to them, I'm not going to second guess that. So I do, but ultimately I do believe that the next best option after C would be B. I firmly believe the judges need to be judges. Setting a minimum term is consistent with the rest of the country, notwithstanding our isolation. You're still part of this country.
The statutory.
No, it would be B. Switch it to B. Judges. Thank you.
Yes, if you retain the existing procedures, I think the biggest thing for me would be reducing the amount of time that it takes before there's a minimum term hearing. I think think 6 months is too long. And I think that's one of the biggest complaints that I heard, listening to the public. And there was an interesting dialogue between an ACO and a former inmate that went back and forth. And I really, appreciated both of them, discussing that dead time. So I think reducing that amount of time is a good thing. As far as whether have it statutory set by the legislature, I think that's a positive thing. I've practiced in Washington State before. They have a determinate sentencing system. I think it works great. It's very similar. If you have this range, it's usually 0 to 12 for people that are, new to the system. And then it goes up to 12 to 24. So there's increasing, penalties and consequences, but it's known. But within that, the judge would still have the discretion to decide how much of that time they're actually serving. And they can also go above or below guidelines, and usually there's a lot of arguments about that when that happens. So if they think something is they see a guideline where they have to set 24 months, but they think this person, what they did, it deserves more. They can certainly do that, or the prosecutors can argue for that. So I think that there's it's basically a hybrid. You're still having statutory, but you're having the judge make the ultimate decision about the range. So it's not just a formulaic solution.
Thank you, Gil. Mr. Brenner?
Yes, I think option B is the only way to go. In light of what's happening across the country, the attack on the rule of law, we have an opportunity here to embrace the rule of law. It's interesting that all the attorneys that are speaking today, for the most part, most of us are former prosecutors, Craig, Brandon, myself, and others. And all of us have a different perspective on why we want this change. I understand from Craig's perspective, and he's voiced that before as a prosecutor, what occurs often where someone thinks they're going to get a sentence and they don't because the board gave them something different. It's all about accountability. I want to be accountable. I want people to know that I'm accountable, and I want to see that in a transcript, and I want to be before a judge. And the notion that a judge only reads a PSR, that's not accurate. And the lock occurs. They see how the defendant and his counsel or her counsel interact with the court. They still have a hands-on opportunity to address any leniencies that are to be presented. So it still allows for both sides to have an opportunity to present this, but in an environment that can be tracked, in an environment where there's accountability, as opposed to having the legislature in option C, as I think that our legislators recognize, it becomes politicized. For example, as a defense attorney, as a former prosecutor, there's no constituency for sex offenders, as an example. They're easily a target by everyone. And every time it comes up for consideration for, say, putting a cap on registration or for having lifetime registration versus, a set period of time, no one supports any changes. You get the harshest treatment, even though statistically, sex offenders who complete sex offender treatment have a less than 3% recidivism rate. And there's no other category. And Mr. Johnson knows that, Fred knows that, we all know that those who finish sex offender treatment are less likely to recidivate. The point being, we have a chance now for Hawaii to stand up and have full accountability with the court system, and it allows everyone an equal playing field in presenting their arguments. That's my position. Thank you.
Thank you, Miles. Mr. Martin?
So in favoring coming up with a new process, let me first say this. For 15 of my 20 years as an attorney, I've been a prosecutor. I've appeared in front of the HPA as a prosecutor and a defense attorney. Any of my opinions expressed today about a new model for the setting of minimum is in no way a comment on the individuals who do the great work at the HPA.
Thank you, Andrew.
I always found your predecessor's predecessor to conduct themselves with integrity and commitment, and it's not a comment on that in any way. It's really about the system. And again, I believe that a shift is best because not only do I believe the judges are in the best positions to be able to determine the minimum, they have the most information available to them. I also think it is the best system for victims. Let me explain why. For those 15 years as a prosecutor, I have been supporting victims' voices, their rights, and it can be challenging as a prosecutor. Because as Brandon touched on, in our office, he was still in our office when I became the prosecutor, we spent a lot of time talking about what it means to pursue justice as a prosecutor. Because there are times when you make decisions, when you take actions that are against what victims want to see happen. And that is a challenge. But it's one that we all take on with commitment, because again, our mission is bigger than just advocating on the position of a single individual. But throughout my time as a prosecutor, in working with victims, in supporting victims, keeping them not just informed of what's going on, but making sure that they feel that they have a voice in what we do in handling their cases, and making sure that their voice is heard, whether it's through me as the prosecutor trying the case, or making sure that they're heard at the time of sentencing. One of the things that I have found to be frustrating and I believe harmful to many victims is the idea that I cannot provide them, even at the time that if we get a favorable plea bargain that calls for prison, any answer as to what that means. If they go through the entirety of a trial, and then we're going and we're arguing for some open sentence. First of all, the battle is to get the judge to determine that prison is the sentence that is just. So part of that process in a victim becoming in front of a judge is to discuss the impact for them to be heard on what that means in terms of what they want to see as justice. And then we got to tell them, guess what? We got to do it all over again. We got to do it all over again. And we're going to have to take you into the prison to do it. And we're going to sit down and have to do this again. And I don't know what the outcome is going to be. I do not believe that that is a victim-centered and trauma-informed approach. Do not. I've never known a victim in my 20 years as an attorney. I've never seen a victim silenced by a judge. I've never seen a victim not given the opportunity to speak. And I think giving them the opportunity to have that voice in front of the judge and to walk out of that courtroom with some certainty that the sentence is going to be between this moment, between this time and this time, is the best approach for victims. That's my feeling. I know there's disagreement in the room on that, but I wanted to put that out there. And I'll leave it at that for now.
Thank you, Mr. Book. Mr. Kennedy.
Well, thank you. So just to be clear, this inquiry is if we were to stick with, I guess we're using the term status quo, what tweaks we would like to see made?
Or if you were to change the existing procedure to an alternative, would you favor judicial setting of minimum or statutory set of minimum?
Oh, okay. I guess so for the first inquiry, if it were to remain with the HPA, I would strongly agree with the idea of some sort of judicial review. And I guess this will segue into the next one. I believe judges are the ones who are in the best position to set the minimums. I'm a firm believer that the judges know the cases better than HPA. At least here on the Big Island, I think the judges take time to learn the cases. They're there from the beginning. There's pretrial conferences where they meet with attorneys. There's pretrial motions. They see the defendant in court. And as Mr. Martin was just saying, I've never seen a judge reluctant to take testimony from a victim. They can appear by Zoom if they're concerned, if they don't want to make appearances. So if we were to stick with option A, the HPA, I think that one tweak would be allowing judicial review. With respect to B and C, I'm kind of a strong believer in allowing the judges the control and the discretion.
Thank you, Mr. Kennedy.
Thank you.
Skeldon.
Can you all hear me? Did you hear me okay? Okay. If we remain with the status quo, I honestly think that HPA really needs help. I think, they talked about how 30% of their time is spent on minimum hearings. I think we all would prefer they spend probably more time on parole hearings and release hearings. Outside the box idea, appoint more members to the board. This would be my big ask, would be create a separate board for each island. I think that would address some of the inconsistency concerns that some people have. It would also give victims an opportunity to be present, easier to be present in front of a board on each island. It would also address the dead time, because I think we could set the hearings quicker. So that would address, I'm going to talk about dead time a lot because I hate to say it, but I mean, I think our island is in a very unique situation when we're talking about overcrowding concerns, because we do have our primary custody facility is HCCC. Everybody knows, I see Mr. Johnson there, he knows it's consistently been the most overcrowded facility in the state for years. They're doing whatever they can. We can't change logistics that we have two major courthouses on each side of the island that require daily transports each day. I really think if we were able to facilitate having those minimum hearings set quicker, we would be able to get people off island faster, and that would contribute to decreasing the overcrowding concerns at HCCC. I am an advocate for statutory mandatory minimums. I think a determinate sentencing structure would also address some of that, those concerns. And with all due respect with my colleague, Mr. Kennedy, I do have concerns with giving the judiciary the authority to set some minimums. We've seen a very sharp shift towards a very defender-focused criminal justice system, and we're forgetting about victims. Just a couple weeks ago, we had a situation where a victim-related case, offender was placed on felony supervision. A deferral was granted upfront over our objection. After 9 months, a motion for early termination was filed. It was set for hearing within a week, and that motion for early termination of that felony supervision was granted. At the end of that hearing, the defendant was asked to step forward to where the judge handed that defendant a candy bar and posed for a picture with that defendant, wishing him the best of luck. And in continuing, and I will say this, that defendant was doing well, but I think a 9-month felony supervision on a case where the prosecutor's office objected and it's a victim-related crime, I think that doesn't send a very convincing, it doesn't convince the public that we have a fair system, So we just as a reminder, we need to remind everyone that, don't forget about the victims here. But yeah, so basically, if we're going to keep it the status quo, I think HPA needs help. They need funding. Senator Wakai, I heard your concern earlier about not leaving it up to the legislature. But with all due respect, I think it may have to come down to that, because we may need to have a shift towards statutory minimums. Because if the state's not willing to put the money, the time, the resources into helping HPA, then that might be the easiest solution. Set statutory mandatory minimums. We don't have to do it overnight. Maybe set out a project of having it done over the next couple legislative sessions. I think it would also send a message to the public that the legislature is looking at addressing victim safety concerns, addressing public safety concerns, and working towards making our community a safer place. That's it. Mahalo.
Thank you, Sheldon. Brandon?
Thank you. I just like to point out, I think there's a way, if we end up going with option B and revising the system, I think that going with option B and strengthening victims' rights and input are not mutually exclusive. I think both of those things can be accomplished by going with a different direction with the way minimum terms are set. And when I talk about prosecutorial discretion and negotiating plea agreements, which is probably 95% of people who are appearing before the HPA is through a plea agreement, not through a trial. Oftentimes when you're a prosecutor and you're stuck with either probation or just picking between 5, 10, or 20 years as a condition of argument or as a stipulated sentence, I think most times victims' frustration are with a probation deal. But if we can return some of that discretion back to the parties involved, including the judge, I think there are ways to resolve cases much more creatively, fairly, and justly that involves, for example, a case where the maximum sentence someone could receive on probation is 1 year on a Class C felony. But if we were to be able to negotiate a 2 or 3 year sentence or minimum sentence as a condition of a prison term, I think cases can resolve much more differently in a way that favors what the victims want in that type of case. That being said, if we are to keep the existing procedures, I do favor some significant revisions to policy. Mr. Huon's report, I agree strongly with some of his recommendations. Most in particular, the increase of resources, obviously, wraparound services, increase of resources to HPA, increasing resources to the CVCC. I think respectfully, what's missing from that list that should absolutely be included is an increase in resources for offenders who are indigent, which is, again, probably 95% of the people who appear for the HPA. So that would include more resources for the public defenders. I know that there was a bill before the legislature this past session, which involved increasing the hourly fees for court-appointed attorneys. So getting more qualified court-appointed attorneys to take on some of these cases, including through the HPA process. Experienced attorneys is very important if we're going to keep this existing system in place in order to improve it. Thank you.
Thank you, Brandon.
What seems to me, just looking at the different proposals, that what we're looking at is, for victims, is that we're looking at minimums being set possibly higher is what it sounds like, in recognition of the nature of an offense and recognition of the unique position of each offender and their history and what their needs are, and also in taking into consideration victims. So I think that that the thought that victims would, instead of appreciating that somebody is sentenced to a higher minimum, it relates entirely to those, very specific issues. And what they would like is something less, is not necessarily what victims would want. I also think and appreciate people's comments about victims' concerns, but having been for 30 years worked with the legislature, first as a legislative liaison for the prosecutors, then in the Commission on the Status of Women, I can say that pretty much every single year, year after year, victims go down and beg to have the statutes changed so that they can exercise their rights. We fought for a decade to have mandatory restitution. We fought for this victim notification system. There's Mothers Against Drink Driving, the Domestic Violence Coalition, the Sex Assault Coalition, not because everything's fine for victims. There's those coalitions because day after day after day, it's not fine for victims. And maybe it is that they don't tell people, the prosecutors, because the prosecutor's interests don't always align with the needs and rights of victims. So the reason why there's a victim community of people on this panel, they fought to have on this panel because the legislature did not include victims initially on this panel. The Penal Code Review Committee does not include victims on that panel either. So there's a voice that is a different voice that is part of this community and part of an advocacy community who we know from the voices, from what people tell us. And that doesn't mean that there aren't other experiences. But I think to suggest otherwise is to, to marginalize or minimize the fact of those organizations and those voices is not something that somebody wants to do. I also find it really, ironic and interesting, the notion that we need to look at what's happening on the mainland. We need to adopt that because they're doing it better. We fought for years to have a constitutional limit for victims' rights because that's what happens on the mainland. And we're told time after time when prosecutors are against that proposal too, that we don't need that proposal because everything is fine here. But, so like I said, I find it ironic to say we need to go with this because everybody else has it when it doesn't apply when there's needs and rights for victims. So anyway, I just wanted to say that about victims. I also think that I like the idea of putting more resources into, that no matter what happens, no matter what proposal there is, we need to look at resourcing whatever there is. We need to have more programming for offenders so that whatever proposal is adopted, we need to have evidence-based programming. We need to not have something that's not proven to work. We need to really focus on implementation. That what is important, I think, after this and what people adopt and accept is that does it get implemented? Do the people get hired? How does the programming get created? So I think that some of the proposals and the threads and the Department of Public Safety and NRSU really go to the heart of that what we need is in some ways beyond what an infrastructure is. We need to provide services to offenders so that they have an opportunity to not reoffend. We need to take those things really, really seriously, no matter what it is that's created. Obviously, we're asking for funding. I'll say something about since we're asking Kate. We had VOCA funding to help victims through the post-conviction system, and we lost that. Most of you probably know if you looked at VOCA funding that the bottom has dropped out of that funding. So we had a great program that helped victims through the post-conviction system. And so we think it's important for victims to have safety planning, notification, all those things we talked about, have someone explain to them what the system looks like so that they can understand what's happening. So we think that's very important. And also we know that some of those systems, some of those previous positions that staff that effort are no longer being supported by some of the offices. So it's definitely needed for victims to have that system.
Thank you, Pamela. Brendan?
I'm sorry, did you call on me?
I called him. I'm sorry.
Yeah.
Lisa.
Oh.
Yeah.
Well, the question is whether if we're going to retain the existing, what are the changes? I think the HBA memo sets out the recommendations that they want. Basically, it's more funding for services to help the procedures now, our procedures work more efficiently. I just want to point out, I think some people have mentioned they want more judicial review of the HBA's actions. Has always been judicial review of the HBA's actions. There's a lot of case law on the HBA's actions. I understand that legislature last year, they wanted to have, I guess, attorneys appointed or being allowed to file move 40s on behalf of inmates right off the bat. I don't know what the procedures were on that. I think the judiciary had some issues with that. I know on the neighbor islands, the courts actually do appoint public defenders to, I guess, help or counsel inmates who have filed move 40 petitions. But I guess the impression that there is no judicial review of HB actions is totally false.
No one's saying that. Yeah. You're saying better judicial.
Okay. And so that would, well, you're not really saying then you're not saying judicial review, you're saying you want more legal representation. Because the judiciary already does that. We want more legal representation or more legal assistance for inmates to file reports. I understand that legislation was that last year, right? So that's really what you want, and certainly that's something for legislators to consider.
I mean, if there's an opportunity to discuss, please, so we can get it.
It's gonna go a bit better for you to talk.
And just
you.
briefly, I understand that people have talked about what victims feel about the current process and how they, I guess, feel slighted in some way, that there's no certainty for them. I would think we would listen to the people who are actually working directly with the victims as well. As Pam pointed out, victims like the existing procedures. They may not, yes, communicate that with the prosecutors as well, because frankly, prosecutors and victims may not always have their interests aligned. But obviously, the victims have made their voices heard that they like this existing procedure with the HPA. They feel it's more comfortable. They feel more heard. There are ways to, I guess, increase consistency. Perhaps you could make there's 2 part-time members of the parole board, could make them full-time, can have more board members. So as Keldon, proposed, and that's sort of a pipe dream, you can have a parole board for each island or each county. And that would certainly help with the timing and the consistency of the well. I think those are the kinds of recommendations that would make the existing process even better. In the HPA's memo, they point out that in 2019, the Prison Policy Initiative actually found that the HPA's paroling procedures were the second best in the nation. And this is so supposedly, odd or unique procedure where they actually discuss cases with the offenders. To somehow dump that just because, the mainland does it differently. The mainland didn't rate on Prison Policy Initiative study. I mean, Wyoming was a shade better, I think because of their legislature, the statutes they had, but to sort of dump the existing procedure simply because, well, we want to join the rest of the mainland and how they do it, that doesn't seem to ring true to me. So the HPA's memo sets out the recommendations in detail. I think those would make the process a lot better.
Thank you, Lisa.
Well, we keep existing procedures, which I favor. I think in addition to the changes recommended by EPA, maybe also review the minimum sentencing guideline. Take into account some of the recent case law, Coulter, Saku, and others. I think that would go along with this issues. Right now, the statute reads that HPA has held the minimum term hearing within 6 months. The average minimum term hearing is held now at 3.5 months after sentencing by the court. I found that if it goes past 6 months, it's because defense attorneys have asked to hold off on a minimum term to combine it with another case that's currently going through the court. So I think that if we keep the current process with HPA, that a couple of additional board members could help the parole board hold hearings at 2 different locations on the same day, and that would further bring down the timeline between sentencing and the minimum term hearing, providing the parole board then could work with 2 or 3 members of those boards to be dispatched out. I think having the courts do statutory minimum is more like a cookie cutter process and doesn't take mitigating and extenuating circumstances into consideration. I think that's a huge mistake. And I do think on a different manner, offenders who are resentenced to probation, by the time they go to HPA on a Class C felony, they've been on probation for 7 to 8 years. They've got 2 to 3 years of pre-sentence credits. If the courts are setting the minimum terms with all those pre-sentence credits, the court's not going to have the information that HPA has with respect to what the person risks and what their needs are, because that's not done until after sentence. So if the courts do that, they're not going to have that dynamic information to figure out what level of treatment the person, what courses the person needs to go to. So that's the beauty of the current system. But I do agree with all of the recommendations of HPA, but I also think that they should review the minimum sentencing guidelines as well.
Wow. If we were to retain the interest procedure, the office would favor option B. And, great guidelines of HPA with these recommendations.
Senator Wakai.
You know, I really appreciate the comments by Pamela Ferguson Bray, because I know this group is focused on the accused, but I think that we need to pay attention to the victims. And Pamela, I'm happy to engage you in a discussion after this meeting as to what we can do statutorily and resource-wise to help you advocate for the victims. And I also appreciated Keldon's comments. Boy, he has a lot of confidence in the legislature. I don't have as much confidence in some of my colleagues to set all of the minimums. And as I really said from the outset, I mean, you know, when government sets policy, the government just kind of one size fits all. And in your world, one size does not fit all, right? Every individual that you guys come in contact with has a different story as to how they got into some kind of criminal mischief. So I'm not too sure that you want the legislature to really be the ones framing what the penalties are going to be for those who violate the law. But I do want to say one thing, though, is as we talk about if we're going to go with the existing process, I read Mr. Hoon's commentary and the recommendations by the Paroling Authority, as well as resources needed for DCR. But what I think is missing in this is the composition of the parole board. I heard a couple of people talk about, oh, maybe we should contemplate making it more members. Before we go down making it more members, why don't we take the politics out of all of this, right? I think that's where we have some problems. And I'm going to be politically incorrect here by saying that all of us have seen over time, we've had some outstanding parole board members and we've had some duds on there. And the duds got to be taken out. And we take that out by having someone other than the governor appointing who the parole board members are. And I like the group that is right here in front of us. I mean, so to me, a very well-balanced group. How about we create an entity of professionals like yourselves? You guys pick, and gals, you guys pick the parole board members and don't leave it to politicians to do that. Because then I think that's part of the root of all the troubles that we're having today is we get people who are not well-versed in the law, have no background whatsoever in all the world that you guys live in, making decisions. It's kind of going back to lawmakers creating all the statutory minimums. Like, I don't know if that's a really good thing for society to have. I mean, in your world, it's about fairness and justice. In politics, it's not about that. It's almost the antithesis of that. So anyway, that's my recommendation. I'm so politically incorrect for saying all of those things, but I think that's what we need to get us to a better place. Thanks.
Thank you, Senator Wakai. Hi, Sonoy, are you still there?
Yep, I'm still here. Definitely enjoying the conversation that everybody's having right now. And I know for me, and I had mentioned it earlier, is that I definitely want to see some change happen. I think we can be a little bit more consistent. I do like the idea of eventually having a group on within each county. However, I don't believe that we are there quite yet. I do kind of want to say though, as I'm part of the Hawaii State Coalition Against Domestic Violence, I actually sit on their board as well, is that we are looking at proposing some legislation coming up this year. And I think that would really tie into what we're talking about here. I do want to say, I mean, and I always say it, is that I'm always on the side of the victim. And yes, we got to do more to help the perpetrators. Obviously, we have to make sure that things are efficient and they run well. But I definitely would like to see some kinds of projects that are put forth towards these offenders that, they need help. We can treat the victim side, but we definitely need to treat the offender side. So I think with all that being said, I definitely would like to see a little bit more change, a little bit more efficiency, if we do stick with this. Thank you.
So let me just go back to some history. So originally, before it was HPA and before it was Board and Pardons Review Group, the governor ultimately had the say on paroles and punishments. Then it was transferred to judiciary, having the final say by the judge. Then eventually in the 60s, it was reverted all the way to HPA, having sole authority. So that's the short history. Now, regarding Third Circuit and Keldon, yeah, we've had discussions regarding PSI. For a while, PSIs, as we've said before, are the most critical element upon intake of any individual coming into prison, because it helps determine the RAD or the substance abuse plan, treatment programs and or mental health issues. And it's a very critical document which versus self-reporting upon intake. Now, I agree with Senator Wakai. And we've had two former legislators separately sit on the board, and both have said that, you know, if they knew what they know now, what they knew at the time they were passing legislation, they would have done it different. They would have done it differently. And that's why I agree with the senator. You know, most of you come from your silos circuits, but the parole board sees everybody. Everybody from all circuits with all history, all their sex offenses, all their murder and stuff. So, but we have to be equal and balanced when we render minimums and look to anything else. The focus on rehabilitation. Hawaii is the only state that by statute, once parole is denied, we have to see them within 1 year for another parole consideration hearing. The only state in the nation by statute, by law. And we do that. And sometimes when you look at our stats, we have more parole hearings per inmate than any other state. So if you look at Georgia, the way they do their minimums and their parole hearings, once they deny, they may not see them for another 3 or 5 or 8 years before they get their next shot at parole. I mean, that's another state. California, Washington, if you talk to Keisha them, you know, they'll acknowledge. Hawaii is very unique because by law, and our laws are very much in focus toward rehabilitation and movement of individuals. So as I said, you deal with separate silos, separate circuits, Hawaii does with everything. So, I mean, the board does with everything. So several examples, when we look at youthful offenders, who aren't youthful offenders, but we see an individual need as represented by defense counsel. We've given a individual, we recommended sex offender treatment after hearing, but we were able to set his minimum so that he could take usually what's prescribed in the facility, comparable program outside. Courts wouldn't have done that because when they sentenced him, they didn't even consider it. And that was because of a plea deal. And when we've asked victims, actual victims of a sex offense on a plea deal that was a 7 out of 20, were you a part of this negotiation? And they were in the hearing in person at Halau, recent. And of course, they wanted more than 7, but the plea deal between prosecutor and defense said 7 years. These are the kind of exceptions that HPA takes. Now, when we look at a lifer or somebody who has a high minimum, but he's determined to be needs medical release, goes healthcare director to the director's office down to HPA, he still has a minimum. HPA has the ability to reduce the minimum and eventually parole based on the medical nature of what was submitted to HPA. Good example, very recently, once we got it from healthcare, we were able to review this individual, reduce his minimum and parole him within 72 hours. The family took custody, put him in hospice, he died 3 days later. But the family at least had the ability to take the individual and provide him comfort and provide him relief before he finally passed. So we had another individual who was determined to be terminally ill, was a lifer, murder. But we were able, again, to provide that compassionate release through the process, which legislation last year said they wanted to recreate the whole thing, when we know we have a system that works. So, you know, the ability to have the reduction of minimum, and if you read what we submitted, the court's mandatory minimum, we have no leeway unless somebody goes and petitions a court to reconsider the minimum, and that could take however long. So the recommendation is, okay, if you're gonna stay with court minimums, then at least allow HPA the ability to reduce that minimum in a chance for whether it's a medical release or they've completed all programs, and get them back into the community if they've been treated and completed all required programs as assessed by the RAD, or the Receiving Assessment Diagnostic Program. Now, when we notice that the indigenous groups across the nation, especially now with Hawaiians, it becomes a thing from how long? If they're highly incarcerated, shouldn't we give them the opportunity to be treated fairly on a one-to-one discussion with the panel and the board for appropriate treatment? I think so. We're trying to be the most humane system in the nation, and I think we are. We're the most progressive. If you look by our law and the submissions, when individuals ask, not necessarily for Rule 40, but they'll write to the board and they'll state their case. Many times we'll run it by the attorney generals to review. And they say, yeah, maybe you should have a minimum, reschedule for another minimum hearing. So half of those type of complaints, we may have to reschedule and redo the minimum hearing again at the individual's request. So, you know, I really think that the existing system should stay, but we can tweak it. I've made recommendation to Director Johnson that instead of waiting 6 months by law, that as soon as their intake, they have a IPP or prescriptive plan set up, we schedule a minimum, and they'd be allowed to take programming and not wait until a minimum. And he agrees. So these type of tweaks can be done without having to go through a whole act of Congress to make these changes. But I still say with option A, with tweaks.
Martha?
Okay, well, I just want to say, first of all, I'd worked with victim services for 9 years, worked in the sex abuse treatment sector, taught about criminal justice system in university, and also worked with domestic violence programs, help setting up support programs for battered women. So I am very agree, but I actually started, and then nobody talked about victims' rights. Nobody talked about victims in the justice system. So I just want to say, first of all, thank you for almost everyone here. Make sure they spoke about victims, and that is such a change in the system. So much appreciated. And just to say, the concern about moving to minimums to be set in the courtroom is not so much that the judge would or wouldn't allow a victim to speak, but it's the victim's intimidation in the setting. If the offender or the offender's family and friends are there, that's difficult for a victim to speak frankly and openly. And then it is also really important to me, and Fred said it very eloquently, but this whole notion of Hawaii actually being a role model. It's not a cookie cutter approach. It's not the way they do it in other places, but the point is it's individualized, very thorough assessment. There's a back and forth that tries to involve all the key players, which is it's valuable. The current concern that I have is when it's in the judicial setting, they may not have a victim impact statement, or they may not have input on the behavior from the time of the offense until a trial is completed, and that can be months, years, whatnot. They won't know what was going on, perhaps, with the offender's behavior. So that's a concern for me in terms of setting a minimum. But so that's why I'm fine with continuing the current existing procedure. And I do see need for changes. So one would be, again, HPA reviewing their guidelines for any needed update. Also see the legislature could look for more funding for programs for incarcerated individuals, and clearly addressing that issue of when they can start the programs when they're incarcerated. That seems to need an assessment, because why would they need to wait? But anyway, that's a layperson's perspective. The other is more funds for post-conviction victim services positions, because it's not, you can't just only ask them to write information about impact. Someone needs to work with them. A lot of people hate to write. It's an emotional thing to write about, that experience that has occurred for them. And so if we really support victims, we need to give them the support to get their input. And so that's why I would really encourage that. If there is some change, we've got to make sure that you maintain the victim's right that's afforded by statute, Hawaii revised statute, to have input in both hearings. And quite frankly, it really is time for victims, and another legislative fix, but to have constitutional rights. Crime victims deserve that. At this point, we know how important, what role they have in the system. They know the impact of crime. Everybody can speak to their various positions, but you need to have a place that crime victims and their families are really deserved to a place in the process. And I think that's it.
Thank you, Brenda. Martha. Craig, are you still there? Any final
Yes.
on that question 2?
Yeah, so my understanding of question 2 is, if we were to retain the status quo, would you favor no changes or consideration of other recommendations? So obviously, because
Or would you favor judicial settings of minimums or statutory setting?
oh yeah, well, I've already stated I favor the judicial settings, which is not a cookie cutter, which is a court looking at the individual as well as the case and the impact on the victim. And if victim impact is not being reported to the court, I have to ask the question as a former prosecutor, is there a failure by victim witness, which is statutorily required to be in every prosecutor's office? In my experience, they've assisted people in getting through the process in terms of filing, preparing victim impact statements, what the court is looking for, and so forth. I mean, I don't know if that's changed over the last 16 years or not, but I do not see a flaw in the system right now that victims don't have that right and that opportunity. It may be a flaw in how the system is currently going. But I think that once you change it to a judicial setting, I think the emphasis then becomes for the victims and the victim witness offices within the prosecutors who say that this is where your voice will be heard. This is what we need to focus on, as opposed to a hearing, months later. And I think that that's also consistent with due process, because that's all taking place in an open court. I do want to state something, a little bit of a response to, though. There is judicial review of the HPA, but it's not automatic, and it's not automatic that attorneys are going to be appointed, and it leaves a lot to the inmate to figure out how to file and get in front of the court in order to get an attorney. So if there would be at least one change in that area to get better judicial review, it would be that the court-appointed attorneys can stay on to file the Rule 40 petitions on behalf of their client and represent them with regard to HPA's conduct. Having said that, that's what I recommend. I'm still with option B for the with regard to the judiciary setting of the minimum. It's case by case basis. It's something that the judge would consider in individual cases. And with respect to keeping the status quo, although I oppose keeping the status quo, of course, it would have to be with significant changes to address the same issues.
Thank you, Craig. Brenda?
If we were to keep the existing procedures, then it would be with the changes outlined by what HPS.
We were at the number 5, question 3. It's 10:47. I'm going to go around. If you have anything else you want to say in regards to the conversation that we had, when I call your name, you can either say yes or no, or make your comment, and then I hope to take a 10-minute break after that. Okay, it's been a long discussion. I've allowed several of you to just go off the question, so because this is a passionate subject, and speak in addition to your stance. And so I'm just going to go around one more time and call names, and let's just see if folks have anything else you want to add to the discussion. Then I'll call for a break. Lisa?
No.
Brenda? Tommy?
Has the commission lobbied any member in a particular position of the task force? Okay. No.
Carmen? Vicky? Oh, thank you. Brett?
Yes. I just want to implore everybody to really look at what we submitted, because we're not advocating stay the same and do everything like it was. We're saying stay the same, but make improvements, which we've outlined.
Thank you, Brett. Ben?
Yeah.
Glenn, Mr. Otay, Senator?
I just have want to reiterate again, do not punt this to the lawmakers, because you gotta realize that, there was a cleansing of the last election. So 1/3 of the House of Representatives is brand new. So that's like having somebody who just graduates from Richardson Law School going straight to the bench and making decisions. That's what you're going to do if you leave it in the hands of lawmakers. So I really implore all of you that whatever option A or B you guys choose, you guys take ownership of this and do not leave it to neophyte lawmakers.
Thank you, Senator. Pete?
Yeah, if this is the time, don't punt this to the penal code review. I was asked to chair that by Chief Justice Moon and then Chief Justice Richardson. They got to look at the entire penal code. Ben was there, Pam was there. They don't have the time to devote anywhere near what we have done here. So I think it's bad. And I agree with Senator Wankai. This is not a thing for that kind of politics. So for consistency sake, I say keep it.
Thank you. Gilda?
Yes. As far as, the changes that, proposed, Fred, I 100% support all of those things. I think that corrections does need a lot more funding to fix a lot of these issues, including facilities themselves. It's been well documented with HCC and the cameras and women's and things like that. It just takes a really long time to fix anything. Even the last time, it was a couple of years ago, I was at Alama for minimum term hearing. The electronic doors weren't working, so they had to use the skeleton keys to open the doors and things like that. So there's just some very minimum safety, issues that need to be addressed, and I think would also help out with morale as well. The ACOs. So, thank you.
Andrew?
Yes, just with regard to the last 2 pages of Fred's memorandum that regardless of which way we go, I'm supportive of the recommendations with respect to HPA, CACC, and DCR.
Sheldon? Can't hear you, Kelvin.
Sorry, just briefly, I think Fred mentioned about Third Circuit waiving PSI. Just for clarification for everyone, that's for situations where we've done that in working with defense counsel, working with the judiciary to try to expedite sentencing for cases where it's agreed upon sentence for probation. If it's amended and it takes away the discretion from agreeing to waiving PSI, I don't have a problem with that. It just won't be that I'm not playing ball. It'll be that you guys said that that's what the rule is. So does the legislature that? That's fine. That's fine by me. But just don't forget the legislature just remind the members of the legislature that the judiciary on the Third Circuit needs help. They need more PSI writers if that's going to happen because they're understaffed. I think in Hilo they only have 2. In Kona they only have 2. We got like thousands of guys on felony probation. So we got to try to figure out how we're going to work with that. I think Fred has provided a lot of good alternative considerations that we should take a look at. I also think it's important that he did mention about that statutory provision for those when they are granted or when their parole is denied, or that they're allowed to have another hearing within 6 months. Maybe that's something we should look at amending. Maybe they shouldn't get a hearing. As it's mentioned earlier, other states don't have necessarily that. It gets denied for several years before they have another hearing. Maybe that's something we can look at as well to try to decrease and prioritize the resources and the work and time for HBA. Thank you.
Miles? Brandon?
Yes, just briefly. I've been listening very closely to the victim advocates here and taking some notes. And I want to say, I'm saying this out of total respect and not to minimize what they've said whatsoever, but I'm not really getting specific concerns, or at least they're not registering with me. As far as there's one that I've heard, which is the victim's comfort in talking in front of the HPA versus in court. But I really like to pin down some of the specific concerns that the victim advocates have about changing the existing procedures to option B, because I really want to see how we can address those concerns. Because right now, I think, as Craig mentioned, in many ways, this can make the victim process better. I think the elephant in the room that no one is really talking about is that, I would assume, is that victims are concerned about lower minimum sentences. So if that's something that needs to be discussed, let's just talk about it. I don't know if that's necessarily going to be the case from switching from the HPA to the judiciary in terms of what minimum sentences are going to be set at. But I would really and genuinely like to hear not a list, but some concrete details about what the victim's concerns are. Because again, I think going with option B and increasing or preserving victims' rights or strengthening victims' rights are not mutually exclusive. I think we can do both through this process. Thank you.
Andrew?
Thank you. My only addition, I guess, would be that we've heard a lot of talk about judicial review if we were to keep the status quo. I'm not really aware of any meaningful judicial review that these HPA hearings get. I never see them go back to the sentencing judge for review. I know over here in the Big Island, we do a Rule 30 motion more so than a Rule 40 motion on a reconsideration. It's filed right away. So the idea that we do have some sort of meaningful judicial review right now, I would disagree with that. And then I would just reiterate that I think the judges are the ones in best position to make the call on sentencing minimums. Thank you.
Craig, final words?
I have nothing to add.
Thank you, Craig. Sonoy?
No, I don't have anything to add right now.
Thank you, Sonoy. Martha?
No, thank you. I don't have anything else to add.
I'm just gonna go back. Miles, are you there? It's the only one.
I don't have that.
Sorry, I'm very close.
Oh, forgot.
It's been a long morning. And Rep. Hashem, I just see you on there right now. Did you have, how long, have you been here for a while?
Yes, I have. I listened to the conversation and I agree with Senator Wakai. Don't pun it to the legislature.
No, it's always good to see the House and the Senate.
I mean, yeah, I mean, whatever, if we're gonna do it in statute, yeah, you guys set everything and tell us what to do. Basically.
Thank you, Rep. Hashem. I'll just tell, yeah, one more time. Miles, are you there? Okay. It's been a very enlightening conversation. As we all know, I mean, from my perspective, you folks are the experts. And I would not be the one to debate one side or the other with you folks. So with that, I'm gonna have some conversations with my oversight coordinator here on our next agenda item, which will be item 6. And in the meantime, and those of you online as well, let's take a 10-minute break. It's 10:58. We should be back here by 11:10. Okay, thank you. Somebody was working. That's right. Somebody was working.
George, can you put a timer on this, okay? Is that possible?
Yeah.
How are you? Good. Come on, you can do it.
See that?
Oh, so.
Yeah.
First every question.
Yeah.
Sort of.
Yeah.
Turn to your agendas. We're at number 5. Notice of intent. If you notice, there's an initial question there that I think would be the foundation of our. When we vote, we'll vote by hands. Carol will confirm the count within the room. George, can you confirm the online count? I prefer those of you online, if you can raise a digital hand, so that it'll be easier for us to see the actual vote rather than you having to turn your cameras on or off. Or if you can, turn your cameras on for this particular portion of the vote. So hands and potential digital. I'm only worried because I'm blind, so that's why I'm asking George to help me in the count. Commission, the Hawaii Correctional System Oversight. Yes.
I'm sorry, I was just wondering if you could change the language in the options, the status quo language. And is there going to be an option that option A with the proposed changes recommended by HPA?
We're gonna go, let me finish one.
Okay, sorry.
Yeah, okay. Good question. Thank you. As the Hawaii Correctional System Oversight Commission's perspective, we were really looking at this task as it was assigned to us, as understanding our mandate in regards to creating less of a punitive model to a more therapeutic model. And should the charge of this particular task force have an effect on systemic change? Yeah, not so much about Hawaii Paroling Authority, its procedures, the manner by which they do their business, but whether or not by removing, can system change occur? And when doing system change, it's really about understanding how more collaboration can occur. Yeah, we've heard a lot from the different perspectives that you were all represent. There were system responses and there were a lot of not system responses. Yeah, so understanding that from the chair's perspective, it's really looking at the issues that we come across in terms of the Correctional Oversight Commission and looking at what our mandate is and at the entire system from the front end to the middle to the back end. And all the players in between is the system serving the people of Hawaii good at this time. Yeah. I don't think that I believe that the system is where it is today for people who are no longer in this room. Yeah. We are responsible for our points in the system right now, and really just thinking at whether or not this move can be beneficial, as in all types of reform in correctional environments or judicial systems. Can it be a foundation to reform? Yeah, and cause further change, specifically for a lot of the concerns we hear here today. Whether we maintain the existing procedure or if we choose to remove the authority. So I just wanted to throw that out there so that we understand that not so much one particular point in the system are we looking at, but rather the whole entire system and the effect the decisions that we make today will have on the decision. Now, the initial question is posed straight out of our mandate. And then there's three options. There's three options. So the initial question, would the administration of justice be better served by removing the responsibility of setting minimum sentences from the Hawaii Paroling Authority? Straight from our statute. Sorry, from the task force. Option A would be, and then we will move on to look at option A. If the task force determines that the administration of justice is best served by maintaining the existing procedure, are there any other recommendations regarding the current practice of the Hawaii Paroling Authority setting the minimum term? Yes.
So I understand where you're going, but you know, when you look at the task force and what they requested to do, I think the first question was study whether parole systems or models utilized by other states are best might be suited for Hawaii. I mean, that's a yes or a no. And then when you look at examine and compare minimum sentences.
This is the question that we're gonna entertain right now, Fred. Okay, and she's let me
That's
finish
number
right
three?
now. Okay.
So we're looking at number 3 now. On what the task force is requested to do.
The first charge in the resolution.
On the actual resolution, which just should be attached to your agenda.
Top of the page.
We go through the first page of the resolution with the whereas clauses.
Yep.
And then if you go to the next page, be it resolved by the House of Representatives of the 32nd Legislature of the State of Hawaii, regular session of 2023. The Senate concurring that the Hawaii Correctional System Oversight Commission is requested to convene a task force to examine and make recommendations regarding existing procedures of Hawaiian paroling authorities setting the minimum terms of imprisonment to increase efficiency of procedures. So that first question was related to that first charge.
Well, I respectfully disagree because I'm looking at this, I'm looking at that. So I think it was kind of jumping the gun, but proceed.
Thank you. Option B, if the task force determines that the administration of justice would be better served by removing the responsibility of setting minimum sentences from the Hawaii Paroling Authority, would the administration of justice be better served by placing this responsibility with the judiciary? And C, if the task force determines that the administration of justice would be better served by removing the responsibility of setting minimum sentences from the Hawaii Paroling Authority, would the administration of justice be better served by placing this responsibility in statute? And there's one more that we wanted to add after the great discussion that we just had, and we're going to throw it out there. It could be option B. Given where you sit today and all the data and information presented to this task force, do you have sufficient information to proceed and vote on option B? Or any of them? That being said, I would entertain a motion at this time.
I move that the task force,
It would be based on that question.
based on option A.
Yep.
I think.
No, it would be on the initial question. Would the administration of justice be better served
So then why is the potential option?
with the option be the motion or the question? Sorry, Candace. Ladies and gentlemen, my attorney.
I'm not sure that the resolution itself mandates the specific language we have to use and
Right.
includes us saying that we would adopt with that the recommendations of HPA. So I'm saying that we could say the task force determines that the administration of justice is best served by maintaining the existing procedures with recommendations, from in the HPA memo. So we're not bound by what you've written as you think the potential options are, right? Otherwise, it includes us making including the recommendations for all of the,
Yes. the first
the, important aspects.
The motion that was requested was whether or not the administration of justice better served by removing the responsibility. That's me as the chair asking you folks, is there a motion to that? Not asking for another motion.
So you're the only person allowed to decide what motions that we'll vote on and whether or not we can include this recommendations of HPA in the motion.
No, we have the discussion and it's voted down. Then we
No, I'm saying that I'd like the recommendation to be, I'd like to
So
make
that's,
a motion.
all I'm saying is as the chair, I'm creating the motion.
But the
Question that we
body
call.
makes the motion and then it's seconded, which is why in Robert's Rules of Order, the body makes the motion. It's seconded by the members of the body and it's
Yeah.
voted on by the members of the body.
I'll make the motion
What is your motion, Yvette?
to incorporate what the chair has requested.
What was that?
Would the administration of justice be better served by removing the responsibility of setting minimum sentence for the Hawaii Paroling?
Make the motion.
I'll second the motion. I'll second the motion.
It's been moved and seconded. Whether the administration of justice be better served by removing the responsibility of setting minimum sentence for the Hawaii Paroling Authority. Any discussion?
So where we've been discussing an option A, the option A would be it maintains the existing position. This now vote is about the opposite, right? It is that it determined to be best served by maintaining the existing procedure.
Whatever the result of the motion, we'll jump into the A, B, or C.
And then where would we fit into including the recommendations that Fred has made to?
When we come down to additional considerations about or A.
So the intention here is to just get a general understanding of where people fall. Would you like to maintain the existing procedure or would you like to shift to a different minimum setting scheme? So that's the intention here. That's like the broad question. And then if the intention is to maintain with the existing procedure, then we would move to what Pam is sharing. Should we incorporate Fred's recommendations? And if the vote is to shift the minimum setting authority, then we would move to a different option. But what the thought process was is that before we decide if we should incorporate new procedures into, or if we should incorporate recommendations, we should first determine where the task force members fall on that initial question of whether HPA should retain the minimum setting authority or it should be shifted to a different body.
But what if more people would vote for A if they felt like that the current procedure would be enhanced by the recommendations?
So the motion on the table, which was seconded, is to remove the minimums from HPA, plain and simple, right? Okay.
It says by maintaining this.
No. The motion, I'm sorry, hold on one second. The motion is the initial, which is a yes or no. And that is going to then determine the next part based on the response to the question, A, B, or C. That is what I believe the chair requested.
But A would be not considered if the vote was
Yes.
not, so then you wouldn't have that as an option to discuss and add additional points.
So basically the questions are set up in a way that really like for people who have a different, might have a different viewpoint, like that their ideas are shut out by the way you raise
That's right,
this
we're
question.
having that discussion.
Yeah. Well, we're not having, you've made, the motion precludes the discussion of that because you said it cannot be included in the discussion. unless one side prevails on this question, we will never get to discussing whether or not we could agree to the current system with Fred's additions.
How's that fair?
Yeah, how's that fair?
It's a yes or no question.
How's it fair to exclude a viewpoint essentially?
Well, that's why
It
you had the
includes-
motion. One second, now we're opening up whatever discussion you want. It's a motion.
Then what I'd like to do is to amend the motion to include that a provision for including the recommendations of HPA.
Yes, I guess that's a point of order as to whether a motion is be amended under Robert's rule. I don't know off the top of my head. But secondly, the way it's set up, if I understand this correctly, is either yes or no. If the answer is no, then it would be option A. And if there's a discussion as to what those options are in A, should people on this body want to incorporate the chair's response, should they do so? But I think it is set up in a streamlined way to see where the members fall as to whether there should be removal of the authority to set the minimum sentences. And if the answer to that is yes, two potential options, as I see it, are B or C.
Right, so A is precluded then, so there's no more discussion
If
about.
the answer to the initial question is no, then it would be, should there be anything, if they retain the authority, should there be option A, which is the recommendation? That's how I understand.
So Chair, would it be possible to just not do that first one and just go through A, B, C, and D motions?
I want to really, for the purpose of time, get the motion that's on the table, decide.
So I listening to the discussion, I guess part of my concern, I don't know if anyone else is in the same boat I am, so I'm gonna say it. You know, I would be voting yes to the motion that there is a better way to proceed, but as to the next question, only under one of those two options.
And I'll just comment on that, is that I what the motion is set up that way. It's a two-part.
Yeah, but what I'm saying, is that, you know, to Pam's point, keeping the existing procedure with amendments would be preferable to me than one of the other two options moving forward.
This discussion.
Yeah. I'm just saying, does this motion allow for that for that to play out? That's what I'm saying.
I think if the parole board retained that authority, if the person wanted to retain the parole board's authority that set minimums, the answer would be, the question would be no, but then you would have the option, right? You could say no, option A, or just straight up no, status quo.
Well, it takes it.
So if there's further discussion, I say all authority should keep.
Go ahead, Fred.
Then if it's yes or no, I say yes, Paroling Authority should keep its position and authority. That's my discussion. We can go change this later on, but.
Senator Wakai?
I wanted to see if I could address Pam's concerns because I don't see that these are mutually exclusive. So I agree with a lot of the recommendations put forth by Fred as well as Tommy Johnson. And depending upon if you go A or B, I don't think that because if you were to go to the judiciary having more say in minimums, that we can't legislatively still address all of the recommendations by Fred as well as Tommy here. So I'm not too sure if that's where Pam is going with this, that somehow maybe you feel that if you go with option A with the judiciary, that somehow everything that Mr. Hoon has recommended is off the table. I mean, Representative Hashim and I are here listening. I don't think any of us is saying that we're going to get rid of the paroling authority. If we got rid of the paroling authority, then I can understand that all of the recommendations will be out the door as well. But nobody seems to be contemplating that. So just wanted to convey to Pam that Rep. Hashim and I are listening. So many of your concerns and the resources that Tommy and Fred are asking for will be taken into consideration. Just my thoughts.
Right. Thank you, Senator. I just wanted to make sure that it could be part of the recommendation from this body. And what it sounds to me, it's like the way this voting is set up, it precludes that possibly becoming a recommendation. Thank you.
And I'm really confused at this point because what I'm hearing is essentially A won't be on the table if you vote yes. It's justice is not served by making this routine. You have to remove it from the paroling authority. That's what you're saying, right?
In this potential
It'd be better,
scenario.
justice will be better served by removing the minimum sentencing from the Hawaii Paroling Authority. And if you say yes, then they're never going to get to A. If I said yes, we would consider A and all those connected to it. But if we said no, which is not likely to happen because many people voted for the previous options of B and C and didn't have the option for D. But I'm confused why you would even have the below discussion if you're already deciding at this first question point. Sorry. Since this
We
is
wanted to get a sense of where everybody is before we discuss it. Right, it's a yes or no. Once you get that, then there's these options. Okay. And then after that, there's another conversation about what else is.
So if a majority say yes to this first motion, somehow we're still going to talk about A?
Check.
I know, that's why I'm saying skip right here.
Chair, a point of order.
Yes.
Did you accept the
Yes.
motion? And then, so we are currently in discussion.
Yes.
Was it move on? And the second, you open to tabling this item just for a minute? So you guys can have that discussion with the executive power.
Certainly.
So you can go into executive session.
Thank you.
Recess. So Chair, that's my recommendation to
good to have attorneys in front of me and behind me. Been a long career and I learned. Is everybody here?
Okay, so here's what we're thinking. I appreciate the feedback. And so we'll talk through this based on our conversation with Candace. So this initial question would be, would the administration of justice be better served by removing the responsibility of setting minimum sentences from the Hawaii Paroling Authority as it exists today? So that would be the procedure as it exists today. Then we would move to option A, depending on the answer to that. Would the administration of justice be better served by keeping this with HPA and including the different recommendations that we've heard throughout the day today?
So you're saying basically we still won't get to A depending on what the vote.
No, that's not
We'll always get to A.
We'll always get to A.
He'd have to withdraw his motion. There'd
Yeah,
be a
well-
new motion and then withdraw the second, and then you start with a new motion.
At least this way you can answer one of the questions in the resolution, which is basically should keep it or not. And yeah, maybe a lot of people can say we shouldn't keep it. However, if we're gonna do it work with recommendations, then we should keep it. So the answers, the questions do not block each other out.
That's not what we're for. Thanks, so thanks.
But thanks for, so you can do a new, if he withdraws, then withdraw the second,
And then
do the new language.
Just let me finish. So then that would be option A, and then we would still speak about option B, which would be the judiciary option, and option C, which would be the statutory option. So still addressing all the different options that we've heard about from all the task force members.
But if we have, like you guys on page 2 have 3 options, A, B, C, would it not be simpler if we all just voted, do you like A, do you like B, or do you like C?
I'm sorry, without the respect, one of the direct question in the resolution is would the administration of justice be better served by removing the responsibility of the Hawaii Paroling Authority? So to answer that point, to answer that directly is, I think, what the initial question was meant to cover, but that doesn't rule out any other question.
I think the concern is that it's almost evenly divided. It sounds like there might be 1 or 2 votes more for removing it. But I think it's important that the legislature sees what the actual count was to know that this is very divided.
Yes.
And answering that question, yes, people would vote for either B or C. I think we're making this needlessly complicated, and people could make a mistake in how they're voting if they're thinking they're voting yes and they're voting no.
If I can add to my earlier point, I mean, the way the motion's been worded, I don't think a vote that says, if the outcome is that the administration of justice would better be served by removing the responsibility from the Hawaii Paroling Authority. I mean, at that point, I don't see an issue with another motion put on the table with the consideration of whether or not having amending the current processes and procedures under which the HPA currently operates could also be considered. So I think that's what we're trying to get to, right?
Yes.
Yeah, I don't see that we have to. I mean, obviously, if a motion's made that we're only going to consider then options B, C, and D, and that's seconded, then we got to consider that motion, right? But I don't see the decision on the present motion that's currently on the table, including a second motion after that to considering option A as well. I don't know.
I'm really confused, I have to say. How could you say it's in the justice is better served if you remove the responsibility from the paroling authority, and then the next point say, but you should still leave it with the paroling authority to make changes? I think you have to say.
2 different things. One is
one is, how does the group feel about removing the authority from the Hawaii Paroling Authority? That's a general question. Number two is, how does the group feel about keeping it with recommendations? Those can both be asked and answered. So maybe we should just two options.
That's how you feel.
Because I think everybody has spoken today to the fact that they would like to see some updates to HBA if HBA keeps that responsibility. That's fine. So,
It falls in what we're saying right now. Yeah.
so, but we help us get it.
Then you have any comments?
That's
The way I understand it is that if there are people on this body who wish to keep the authority as is, the answer to the initial question is no. They would have the additional option of saying no, but with recommendations, which would be option A. Then the other way to go on the initial question is if the answer is yes, then obviously you wouldn't say yes A, you would say yes B or yes C. I believe that this setup is streamlined, articulate way to get this task force towards the report, which addresses the main function from the resolution, which is why the initial question, as I understand it, is written the way it is. So I do believe it is a two-part, yes, no, followed by one of them. That's my understanding. If people want to retain the authority and adopt Chair Hume's recommendation, it sounds like that answer or that vote would be no, option A. There's someone that believes everything is fine and nothing needs to be addressed, simply be a no.
Any more thoughts online?
Let's take a vote. Let's move forward with this.
I don't
Let's
know.
move this month, yes.
If you
Miles,
can
Miles, is
You
it-
have-
taking a vote on, and which option, A, B, or C?
see
Move
that
on.
today at the end of your motion, at least I see the distinction then, so you can then go to A, B, or C. But I don't, if you don't add that, I don't get it. Sorry.
Okay, so what if we remove the motion on the table and then we just allow for a vote on A, B, or C? But did you say D?
Some you would add it.
Oh, if we take away the initial one, then you would.
And then
Oh.
people would just vote for one. Oh, we have Craig online, something.
I am generally against having three options in a motion. Motions should be up or down, and then you move on to the next question. Okay, I think we can answer all three questions about the preferences of A, B, and C once we get through the first motion. And being afraid of losing the first motion and then not having your say is not a consideration, because you can make another motion. But I don't believe in amending motions or changing motions so that we add options to it. It's up or down, and so I call the question.
And this is Andrew Kennedy from the Big Island. I would agree with Craig DaCosta on that.
Any further discussion?
So are we gonna go A, B, and C and skip this first one?
Well, I think
There's
it's
still a
meant
motion on the table.
Yeah,
You would-
you gotta
No, I
put the
didn't.
motion on the table.
Well, I have to say this to procedurally, if we're gonna stick with procedure, I totally understand. Anne started a motion, but told she wasn't allowed to do that, so there was no second.
Mark started the motion, and then you interrupted and said, well, you want to make, but Mark started the motion.
Oh,
Yeah.
oh, I didn't know you were,
Mark started
I
the
thought you were
motion.
waiting, you were entertaining a motion from the floor.
Mark
Yeah,
started the motion.
we're making a motion. Then he seconded it and he seconded too, or?
No, I was asking for a motion on the question that we have here. He did the motion. So, So we clear. Call for the question is put forward. I hear no further discussion. We'll take a vote by hands. Online, as said before, your hands or your digital hands. Carol will confirm the count inside, and George confirm the count on the line. In regards to the question, the motion, the administration of justice be better served by removing the responsibility of setting minimum sentences from the Hawaii Paroling Authority. All in favor, raise their hands. George, let me know when you're done. All opposed, raise your hands. Online, we're voting against the motion on the table. Raise your hands. Thank you. Any abstentions?
I guess I would point where on Mr. Siegel, he had to, there was a wildfire, he had to evacuate, send me over his vote. So I can state that now.
Who is this again?
Brandon Siegel.
Oh, Brandon.
from Mo.
Thank you.
His vote is yes.
Evan, yes. George, I didn't have any, how many online for now?
That's the first question. Yes. So 5. 5 no's. How many yes?
Yeah, so it's 11 to 7. 5 in the room. 5 on.
4. Total number of yes. So 11 yes, 7 nays. Motion is passed. Next step.
Okay, so.
Go ahead, following motion.
Would the administration of justice be served by keeping the current practice of Hawaii Paroling Authority setting the minimum terms of imprisonment with recommendations?
Thank you. Second. Thank you, Fred. Any discussion?
That we include the submitted recommendations that was sent out to all task force members as an attachment.
If I could add a review of HP minimum safety guidelines. So it's part of the earlier discussion.
In regards to the current motion on the ground, we will be adding the recommendations submitted by Hawaii Paroling Authority that was in the packet that we sent to you, as well as review of the minimum setting guidelines. Any further questions?
Please repeat the motion in its entirety, and then for the record, if the original move on as second agrees to the amendment.
I agree.
It's an amendment.
Yeah.
Okay, so, would the administration of justice be better served, by maintaining the current practice of the Hawaii Paroling Authority setting the minimum terms of imprisonment with recommendations, including the review of the minimum sentencing guidelines and the recommendations presented by HPA Chair.
Call for the vote. No further discussion. Same as before. Are you raising your hand?
For discussion?
Yeah.
Yeah, just one point. And that is that as it currently sits, just this option A by itself, I just want to explain, I mean, my vote's going to be no. There are circumstances when it would be yes, and that depends on what the other options. So I'm just saying that, just explaining my vote.
Okay. Same method of voting, hands please, digital hands on blind. Carol will count the hands inside and George will count online. All in favor, say yes.
Yes.
Yes, so raise hand.
Raise hand, sorry. Good, George. Thank you. All opposed, say same. All opposed, say no. Raise your hand. Sorry.
No.
Totals. Thank you. Any abstentions? Seven yeses and 9 noes.
Sorry, so I vote?
So now are you there?
Sorry, yes, yeah, I'm on a crisis call, so I had to take a crisis call. Hold on. Sorry. I'll vote, yes.
Actually, I think if she was absent on the first one under crisis call, then I was wondering whether the numbers didn't add up. Then that might change that.
Are the numbers the same on both voting totals?
There wouldn't be. One was a proxy, who's no longer here. I don't have
Oh,
authority for that question.
Okay. That's why it's not. Option B.
Would the administration of justice be better served by placing this responsibility with the judiciary?
That would be the motion.
I'll make the motion.
I'll second that.
Any further discussion?
So for option B, I think the only way it makes sense is really a combination of B and C. And that is where you need to have some starting point for the judiciary. The biggest to me, the biggest argument in favor of keeping the use of the Hawaii Paroling Authority is the consistency. I think to provide consistency and a clear process that the judges would need to follow, they are going to set the minimum, which I do believe they are in the best position to set the minimum. I think it makes the most sense if they have a presumptive starting point, which would be, I believe, best approached by this body making recommendations to the legislature on what exactly those presumptive points should be, based especially on some of the comments made earlier today. So just leaving it up to the judiciary without further guidance, I think puts you in a position where you run the risk of judges being all over the place, right? But putting it in the hands of the judiciary with a presumptive starting point with a clear statutory scheme where they can make mitigating and aggravating findings that allows them to move above and below the set minimum is what makes the most sense. I don't think the motion on B provides for that particular framework, but in principle, yes, but not just alone.
I can respond to that. I agree with your points. I think those are points well taken. I agree with the scheme you are, a statutory scheme or some sort of presumption envisioning. Maybe not so far as guidelines like, say, the federal scheme, but something like it. I do believe the language of option D is simply saying who is making the call. We have a long way to go in writing a report, a lot of input to put in. This is just a guidepost. I would ultimately agree with you. It would probably have to have something like that. And I just want to say this group, this is not saying that there should be unfettered discretion by the sentencing judge in setting the minimum. This is simply who's making the call. I believe it is in response to the last meeting in which the proposal was a straight statutory, where a statute would be, say, a percentage of the maximum. That's it. And this is designed to be in contrast to that. So I do agree that there are further discussions that need to be had, but this question is who bears the responsibility? And I think we are in agreement, or at least I think that there is some agreement as to that should be with the judiciary. Thank you.
So if you say that there could be mitigating or other circumstances, that kind of puts a plus or minus to the sentence versus an across the board type of sentence by statute. I agree that it would have to be statutorily enacted, but again, then the consistency gets swayed when you have other variables that could come into the judge's mind when he or she renders a sentence. Other states, if it's 33% across the board, 50% across the board, plain and clear as what people were referencing earlier. But if you're going to allow for variables to deviate from the minimum, then it's the same as HPA.
I would just again respond by saying that this is definitely a robust discussion that would happen down the line.
Definitely.
Again, this vote today is to at least get us started as to what this report's going to look like.
And part of the discussion too is who is in the best position. And I understand there's difference about that, right? But I see it as the judges being in the best position to make the call.
Is there any changes to the motion with respect to the discussion? Say,
No, this is just a discussion. I maintain the motion.
Any further discussion online?
So,
Okay, would the administration of justice be better served by placing this is the setting the minimum terms of imprisonment responsibility with the judiciary?
Show of hands. All in favor, raise your hand. Thank you. All opposed? Online, all opposed, please raise your hand, show your sign, your hand. Thank you, Sonoy. Any abstains?
Just again, Chair, Brandon Siegel would have voted option B.
That came out to 9 and 9.
Okay.
This is the last option.
Would the administration of justice be better served by placing this, and this being, setting the minimum terms of imprisonment responsibility in statute?
Any motions?
Sorry, Chair, can you repeat that? I couldn't quite hear it all the way.
Would the administration of justice be better served by placing this responsibility in statute? And this would be the minimum term, setting the minimum terms of imprisonment.
Hearing no motion, I'll call it again. No motion.
Well,
I'll second for discussion.
Will be moved by Fred and seconded by Kuike. For option C that was just read by Kara. Any discussion?
yeah, by putting a statute, be consistent across the board, no deviation. Be fair across the board, no matter who comes into custody. Which would make it very simple for corrections and incarceration. And as far as changes and stuff, it can happen, hopefully, for further review by allowing changes in the minimum after their sentence and incarceration.
But that doesn't allow for any mitigating or attenuating.
I know.
Or.
And so when the population soars, it goes.
That's exactly what's gonna happen.
Yeah. So I mean, if that's the flavor of things to go statutorily, like what we've seen in other states and high populations, put it in statute and then have a discussion on how they're gonna set it. But then that relieves judges from having to waiver and go above or beyond what their standards may
But the
be.
cost of the state will be after.
I know, Tommy.
Very well aware of dollars.
But it will also be very, everyone would know, the certainty would be right there.
Exactly.
But listen, guys, state's not gonna wanna spend billions of dollars to build new prisons, and that's what's gonna happen. We're gonna ship guys to the mainland, more guys to the mainland. Okay.
Yeah.
Job security.
Overtime.
Not for me, but.
Liability.
Any other discussion on this? Anybody online?
There's gonna be massive resistance to this. I mean, I don't doubt this. Kind of control against this idea. You heard from one guy and actually, they have no interest in it. You can have to go tonight.
Okay, same thing as before. We'll call the vote by hands. All in favor, say, raise your right hand. Online, we're asking for yes votes.
There's a right hand, my other left.
Yeah. But can you do yeses again?
Okay, I'm just joking. So are we voting on what are we voting? Who lost here?
The statutory.
Statutory
option.
option.
Yeah,
Yes,
I'm against that. So,
three.
Three count.
Three in the room. One, two, three. Was anyone online, Kelvin?
All against that? Raise your right hand. Five and 11. Thank you. Cautious of time right now. 12:15, everybody. It's been long, been frustrating. It's been whatnot. Our next meeting is scheduled for September 12th. What are our next steps? Hopefully, we'll have an answer for you on for September 12th as we discuss what just happened today among ourselves. You know, it's not one side is elated and one side is frustrated. It's everybody's frustrated. We've heard a lot, but still have a long road ahead of us. So we're most likely not going to be submitting any recommendations by August 1. We may ask for an extension of that.
Can I still participate if I'm not chair?
Yes, we'll look at Tommy's budget for consulting.
I signed up as a volunteer, so I'm not charging.
Okay, thank you, Fred. Thank you so much. Thank you, Tommy. Okay, yes, you are adjourned. Thank you guys online. Appreciate your time.
Thanks, Kelvin.
No,